Bill Matlock was your standard issue, a run-of-the-mill bank robber, if that kind of person even exists. What Bill did was rob a federally insured bank in Wisconsin, which is illegal. What Bill did not want to do was go to prison for his crime. So he turned to the law. In this case, his objection was that when the police came to arrest him in the front yard of the place he was staying in Parodyville, Wisconsin, they illegally searched a diaper bag. Let me explain. Now, the place Bill Matlock was staying appears to have been a tad crowded. The home was leased to Mr. and Mrs. Marshall. Mrs. Marshall and several of her children occupied the home. One of those children was her adult daughter, Miss Graff. Miss Graff cohabitated one of the home's bedrooms with one of her children and Bill Matlock. Do you see what I mean? Seems kind of crowded. At the time of his arrest, the officers knew Bill Matlock lived in the congested house, but did not know which room he occupied or if he would agree to a search of that space. Miss Graff allowed 3 of the arresting officers into the home. They explained they were looking for money and a gun. They asked for her permission to search the house for these items, and she said yes. This included the east bedroom on the 2nd floor, which she explained she shared with Bill Matlock. There, the officers found $4,995 in cash in a diaper bag in the only closet in the room. Now it looks like the officers know who robbed the bank. The only question of importance here is whether a third party, in this instance, Ms. Graff, can grant a valid consent to search the area that the officers intruded upon. Were the officers even reasonable in their conclusion that Ms. Graff shared the space with Bill Matlock? That is, could she even grant a consent in the first place? Let's take a quick look at the facts. Ms. Graff led the officers into the bedroom where they found the money. Ms. Graff told the officers that she and Bill Matlock shared the one dresser in the room and that the woman's clothing in the room was hers. She explained that she and Bill Matlock slept together regularly in the room, including that morning of that day. The room bore every evidence that it was also occupied by a woman. So yeah, Ms. Graff appeared to have the ability to grant access to that room. But doesn't Bill Matlock have a say in who plunges into the diaper bag found in the bedroom he is cohabitating? Shouldn't he be consulted before the officers find the money he stole? If you are familiar with the cases of Georgia versus Randolph and California versus Fernandez, both which are subjects of other FLETC talks, then you already know this. If a person with the right to object to a consent search is present, and in fact objecting, the government cannot override that objection with someone else's consent. What of Mr. Matlock? If you recall, he was lawfully arrested in the front yard of this home and removed from the scene. Whether he objected to the search or not is not part of the record, and for our purposes, not terribly relevant. What's important to know is that he was not present to state his objection, even if he wanted to. Can Ms. Graff then grant a valid consent to search the room she shared with Bill Matlock? The law of co-tenancy makes this easy. Certainly she can. Ms. Graff has just as much right to allow the police in the room in which the officers found the incriminating evidence, and anyone else, and absent Bill Matlock's objection, remain valid consent. The lesson of this case, I suppose, is to be careful which diaper bag you hide your stolen money. It might just be that someone else holds the key to your secret. And the story of the Fourth Amendment continued on. I am Shamika Harris, and this has been a FLETC Talk.